Power rarely collapses all at once. It fractures under pressure, quietly at first, through decisions justified as necessary, framed as temporary, and defended as lawful until the law itself is bent beyond recognition. In December 2024, South Korea, a nation whose modern identity was forged in resistance to authoritarian rule, crossed one of its most serious constitutional thresholds. A sitting president declared martial law. Troops were deployed into civilian politics, and the institutions designed to restrain power were forced, once again, to ask whether they could. This is Court of the Crane. Tonight, we examine not a sudden coup, but a slow constitutional erosion, the decisions, justifications, and consequences that culminated in the impeachment and removal of President Yoon Suk-yeol. This is not a story of ideology. It is a story of boundaries, and what happens when those boundaries are crossed. Yoon Suk-yeol did not rise through politics in the traditional sense. He rose through prosecution, a career defined by investigation, confrontation, and an uncompromising view of legality. As Prosecutor General, he gained public attention pursuing corruption cases that cut across party lines. Supporters viewed him as incorruptible. Critics saw a man accustomed to power without democratic accountability. When he entered politics and narrowly won the presidency in 2022, Yoon promised order, discipline, and reform. But from the beginning, his administration governed in a climate of deep polarization, one where legal power and political power increasingly blurred. The presidency he inherited was constitutional. The presidency he exercised would ultimately be judged otherwise. And to understand the crisis, one must understand the environment in which it unfolded. South Korea's political system is adversarial by design, but in recent years, that adversarialism hardened into paralysis. The legislature and executive stood opposed. Protest filled public squares. Prosecutorial authority, historically influential in Korea, became politicized in the public imagination. Each side believed democracy was under threat from the other. What followed was not compromise, but escalation, and the quiet normalization of extraordinary thinking. In October 2022, during Halloween celebrations in the nightlife district of Itaewon in central Seoul, a district known for narrow, winding alleys and teeming nightlife, a deadly crowd surge turned nighttime revelry into horror. At approximately 22:20, a crush occurred in a steep, narrow alley near the Hamilton Hotel. An estimated 100,000 people had filled the district for what was the first major Halloween celebration since COVID-19. Many dressed in costume, seeking release after years of pandemic constraints. The result, 159 people dead and nearly 200 injured, the deadliest such disaster in modern South Korean history. The victims were overwhelmingly young adults, many in their teens or 20s. Among them were foreign nationals. As investigations proceeded, it became clear the tragedy was not simply the result of panic or unforeseeable chaos, but of structural failure. Inadequate crowd management, insufficient police presence, failure to activate crowd-size monitoring systems, and no real evacuation or crowd control plan for what should have been anticipated as a major risk night. In the immediate aftermath, Yoon publicly expressed sorrow and pledged to get to the bottom of what went wrong, promising transparent disclosure of findings, accountability, and a broad reform of public safety and police systems. At first, many took that as an acknowledgement of responsibility. But as the months passed, the story took a different turn, and Yoon's actions became a new flashpoint of controversy. In January 2024, the National Assembly, with strong representation from opposition parties and substantial support from civic and bereaved family groups, passed the Act on Uncovering the Truth, Preventing Recurrence, and Protecting the Rights of Victims in the Itaewon Tragedy, establishing an independent special investigation committee to re-examine the causes, assign accountability, and guard against reoccurrence. But the ruling party to which Yoon belonged, the People Power Party, boycotted the parliamentary vote and recommended that Yoon veto the bill, arguing that the bill, as written, would lead to a partisan, unbalanced committee. On January 30th, 2024, Yoon heeded that recommendation and vetoed the bill. The response was immediate and fierce. For many of the bereaved families, the veto was a symbolic slap, not a gesture of healing, but of erasure. And as one family group leader said, "We have never spoken of compensation, because that is not the essence of this issue. We will continue our fight until the end," signaling they sought truth and accountability, not money. Civil society organizations, including human rights bodies, condemned the veto. The head of the National Human Rights Commission of Korea urged the president to sign the bill, stressing that only an independent investigation committee could reveal the full facts and implement systemic reforms to prevent future catastrophes. Critics portrayed Yoon not as a reluctant leader overwhelmed by tragedy, but as a leader avoiding accountability. The move was widely interpreted as protective of bureaucratic inertia and institutional self-interest, a refusal to confront systemic failure. By the time the martial law crisis erupted more than 2 years later, in the court of public opinion, the Itaewon disaster, and Yoon's response to it, had already become a stain on his presidency, a test case of whether public safety, institutional responsibility, and the victim's demand for truth could outweigh political convenience and institutional defensiveness. If Itaewon revealed the cost of institutional neglect, December 3rd revealed something even more dangerous. What happens when authority attempts to shield itself from accountability altogether? On the night of December 3rd, 2024, the tensions that had simmered for months between a polarized legislature, an embattled executive, and a fracturing public snapped open. At 22:27 Korea Standard Time, President Yoon, addressing the nation on television, declared a nationwide state of martial law. He justified the drastic step by accusing the majority-held Democratic Party of Korea in the National Assembly of acting like a legislative dictatorship, colluding with pro-North Korea anti-state forces, and undermining the constitutional order. Under this degree, political activities, including operations of the National Assembly and local legislatures, party activities, protests, and rallies, were suspended. Media and publications were placed under the control of the newly declared martial law command. Strikes, work slowdowns, and gatherings deemed to incite disorder were banned. Even medical personnel, including striking junior doctors, were ordered back to work within 48 hours under threat of punishment. Within hours, panic, confusion, and outrage spread. Soldiers and special forces reportedly moved toward the grounds of the National Assembly of Korea. There were reports that orders were issued to detain lawmakers, block assembly entry, and curtail judicial and legislative independence. But the attempt to impose military-backed rule hit a wall almost immediately. Legislators convened an emergency session. At around 1:02 a.m. on December 4th, nearly 190 lawmakers from across parties voted unanimously to lift the martial law order, rejecting it as unconstitutional. Facing a political and constitutional revolt, the government formally rescinded the decree a few hours later. By 4:30 a.m., the martial law command was disbanded, and troop withdrawal from parliamentary grounds began. Subsequent investigations would reveal that the declaration was not improvised. According to prosecutors and corroborated by testimony from senior officials, discussions about invoking martial law, including the plans to detain key political rivals, had occurred in advance. Reporting later confirmed that Yoon had explored scenarios in which opposition leaders could be neutralized under emergency powers, framing political obstruction as a national security threat. For many observers, the episode was nothing less than an attempted self-coup, the first time in decades that a South Korean president tried to subvert democratic institutions with military force. The fallout was swift and severe. Ministerial resignations followed. Military and security officials were placed under investigation. And within days, the opposition initiated impeachment proceedings against President Yoon. What was once a gamble for strengthened authority became the final undoing of his presidency. In South Korea's constitutional framework, martial law is not symbolic. It is an extraordinary measure, reserved for war, invasion, or rebellion. It permits the military to assume domestic authority and restrict civil liberties. The question was no longer political. It was constitutional. By late 2024, the public's memory of the Itaewon disaster was still fresh, a deep wound in the national psyche. When Yoon vetoed the special investigation bill in 2024, it is widely seen not as a bureaucratic disagreement over procedure, but as a refusal to subject the institution he led, police, emergency services, and city administration, to thorough public scrutiny. By declining to back an independent commission, the president signaled that institutional impunity, or at least institutional protection, took precedence over transparency and justice. Hence, when months later he attempted to override the Constitution with a martial law decree, for the public it was not an isolated gamble. It felt like the culmination of a broader pattern, one in which the power was used to shield failure, silence dissent, and avoid accountability. The two crises became deeply connected in the public mind. Itaewon, as a tragedy born of institutional neglect, and martial law, as the constitutional panic born of political neglect. Later revelations that the decree had been discussed, modeled, and internally justified ahead of time only hardened that perception, transforming suspicion into confirmation. In that sense, the collapse of his presidency was not sudden. It was seeded in 2022, in the dark, narrow alleys of Itaewon, in the bodies left unprotected, and in the decision not to seek truth. The Constitutional Court proceedings were not a replay of criminal trials. They were an inquiry into the constitutional survival, a formal, legal question about whether the president's actions had so ruptured the system that he could no longer occupy the office entrusted to him. Over months, the justices sifted through a dense record: the late-night presidential decree, internal memos, deployment orders, recordings and timelines of troop movements, testimony from military and police commanders, and statements from cabinet ministers. The central legal frame was narrow and austere. Did the president exceed the constitutional limits of emergency authority? Did he neglect his duty to preserve the constitutional order? And did his actions materially threaten representative government? The court's written opinion emphasized consequence over motive. It asked whether the effects of the December decree, the mobilization of troops to the grounds of the National Assembly, orders to curtail political activity and media freedom, and reported plans to detain public officials, had provided a grave breach of the separation of powers and the rule of law. The justices concluded they had. In its ruling, the court described the move as exceeding the justifiable scope of emergency powers and inflicting a serious challenge to democracy. The court further rejected the argument that the brevity of the decree mitigated its severity. In its ruling, it stated that the Constitution does not measure danger by duration, but by intent and effect, and that even temporary military intervention in legislative affairs constitutes as an intolerable rupture of democratic order. On April 4, 2025, the verdict was delivered. 8 justices, 8 votes, unanimous. The court upheld the National Assembly's impeachment motion and ordered Yoon removed from office. The decision made clear that the remedy was not about partisan consequence. It was about institutional survival. If a president could deploy armed forces against the legislature and the courts on a bare political claim, the constitutional bargain itself would collapse. The court's language was also precise about duties. It faulted Yoon for failing to exercise the minimum constitutional duty of protecting the democratic order, not standing above politics, but by refraining from invoking extraordinary powers to solve political disputes. The unanimous judgment held that some acts, however briefly executed, can so alter the balance of constitutional power that removal is the only proportionate remedy. The effect of this verdict was immediate and procedural. Suspension became permanent removal. The presidency was vacated, and the law required a prompt election to restore democratic legitimacy. The court had not convicted Yoon of criminal wrongdoing. It had excised him from the office for having violated the constitutional order he swore to defend. Removal from office closed the constitutional chapter, but it opened another, criminal accountability. Political impeachment and criminal prosecution proceed under different logics. Impeachment answers whether a leader can remain in office. Criminal courts ask whether the leader broke penal law and should be punished. Within weeks of the court's ruling, prosecutors moved swiftly. In late January 2025, special prosecutors indicted Yoon on charges related to insurrection and rebellion for his role in ordering and directing the martial law declaration, an extraordinary charge that, in Korean law, carries the gravest penalties. The indictment alleged that the martial law decree and the others tied to it amounted to an attempted use of force to obstruct the legislature and override constitutional governance. Yoon's legal team denounced the indictment as politically motivated. Prosecutors argued the gravity of the December decree required criminal review. The criminal investigations were broader than a single indictment. Special prosecutors and investigative teams examined the role of cabinet ministers, senior military officers, and presidential secretariat staff. Arrests, detention hearings, and requests for arrest warrants swept through the ranks of the former administration. Some senior officials were held, others questioned. Courts repeatedly weighed requests for detention, the seizure of documents, and the risk of evidence destruction. These parallel inquiries emphasize institutional accountability. If commands had been issued that suborned military force to political ends, those who executed or enabled those commands could face criminal exposure. NBC News later reported that prosecutors believed the martial law plan was designed not merely to suppress unrest, but to decisively remove political opposition under the guise of emergency governance, a finding that elevated the case from abuse of authority to alleged insurrectionary intent. Human rights and legal observers welcomed the distinctions the two processes preserved, while warning about overreach. International rights organizations described the impeachment and subsequent prosecutions as an affirmation of checks and balances, and urged that prosecutions proceed according to fair trial standards, with full respect for due process. Human Rights Watch, among others, framed the National Assembly's impeachment and the court's subsequent removal as a necessary defense of democratic norms, while noting that criminal cases must adhere to established evidentiary standards and safeguards. What followed was slow, institutional work. Indictment papers, pre-trial hearings, evidentiary disputes, and appeals. The criminal cases raised novel legal questions about presidential immunity, the definition of rebellion under contemporary conditions, and the line between emergency powers and criminal conduct. Prosecutors pressed on. Defense teams sought to frame the decree as lawful emergency action. For the public, the difference mattered. The Constitutional Court had answered the political question of whether Yoon could be president. The criminal courts were now asked whether he should be punished under criminal law for the same acts. For South Korea, the impeachment reopened historical scars, memories of authoritarianism, emergency rule, and fragile transitions to democracy. For the public, trust fractured further. And for future presidents, it drew a line, not theoretical, not symbolic, but enforced. Power may act swiftly. The Constitution responds slowly, but when it responds, it speaks with finality. History rarely announces its turning points. They arrive disguised as procedures, as late-night votes, sealed orders, emergency decrees, and justifications written to sound lawful even as they strain the law itself. The impeachment of President Yoon Suk-yeol was not the collapse of the South Korean state. It was a test of it. A test of whether democratic institutions could restrain power when power claimed necessity. A test of whether law could assert limits when those limits were challenged from within. The Constitutional Court did not judge ideology. It did not rule on popularity, personality, or motive. It ruled on boundaries. And in doing so, it reaffirmed a principle hard-earned in South Korea's modern history, that authority flows from the Constitution, and not the other way around. But this story is not finished. Removal from office answered one question: could Yoon remain president? The criminal courts now confront another. What are the legal consequences of what was done while in power? That journey, through indictments, trials, evidence, and judgment, is still unfolding. And in our next episode, we will follow it. Because history does not end when a court adjourns. It continues in institutions, in memory, and in the precedents left behind. This has been Court of the Crane, where history is not retold, but weighed. We now ask the unanswered question that faces every democracy. How close can power come to the edge before the law must intervene? If you found this analysis valuable, consider liking the video and subscribing to the channel. It helps support long-form, careful investigations like this one, and ensures that you won't miss the next chapter in this ongoing case.
감사합니다.